We're on the record in the matter of the people of the state of Michigan versus Frank Andrew Stevens. File number is 22-03370. Council appearance.
Morning, Judge. May it please the court. My name is Richmond Riggs, P33863. I'm an Assistant Attorney General. I appear on behalf of the people of the state of Michigan.
And Luann Limmerman, also AAG on behalf of the people of the state of Michigan.
John Passenger, P39384, co-counsel for Mr. Stevens.
John Moodhart, Your Honor, co-counsel with Mr. Passenger for defendant Stevens.
Frank Stevens, defendant.
Thank you. Today was the date and the time that was set for a probable cause conference. We tentatively scheduled an examination for June 29th at 9:30. How are we proceeding at this time, counsel?
If I may, Your Honor, on May 25th, we received a substantial quantity of discovery from the Attorney General's office. We're working through that at this time. There are about 900 documents that were not produced. We've asked for a privilege log on those via writing, which Mr. Riggs has not had an opportunity to review yet. We're asking for some additional things by way of discovery. So our request would be that we essentially use the probable cause exam date or something about that time as another probable cause conference and set the probable cause exam probably back until at least mid-late July.
That's perfectly fine. So we will continue the probable cause conference to June 29th at 9:30 in the morning. And then I'll get a new date for the examination.
All right, Judge, June 29th, 9:30.
Right, hold tight. I'm gonna get you the date for the exam while you're all here. July 28th. Does July 28th work?
If
Your Honor,
that's gonna-
that doesn't work.
That date does not work. I just told you.
Right.
Are there days of the week we're shooting for, Your Honor?
I'm sorry, how long? Do you have an estimated amount of time that you would need to run an exam if an exam is gonna run?
We think it's going to be at least the better part of a day and maybe even stretching beyond.
A full day?
Is there a day of the week we're shooting for, Your Honor?
Typically, we schedule it on Thursdays and Fridays, but we would have others on that date. So because you need almost a full day, I'm gonna try to find another slot.
Okay.
Maybe a Tuesday. And that could be typically have just.
I have Tuesday, October 3rd that looks pretty good on my calendar.
October?
Yeah, I can work backwards if necessary, but I don't think that's too long, really. It's a case that's been a number of years in the pipeline, so.
Well, yeah, you're a defense counsel. If you want to go in October, that's fine with me.
How does anyone else look on October 3rd and the court, of course, most importantly?
Which date in October?
I was looking at Tuesday, October 3rd, because you'd mentioned a Tuesday.
Okay, that works for us. Any objection from any of the other parties?
No, that works for me, Judge.
Fine.
Okay, October 3rd at what time? 8:30. It'll be October 3rd at 8:30.
8:30. Okay.
That's correct. Okay, any additional matters that should be addressed on the record today?
I'm sorry.
Just confirming that would the preliminary examination is in person, obviously. I mean, I don't think it needs to be said, but I just want to make sure.
That is correct. The preliminary examination will be held in person at the court as previously held, the probable cause conferences can be via Zoom. And then we'll get Mr. Stevens' fingerprints at the time of the examination.
Very good.
Very good.
Okay, any additional matters for the record?
Nothing at this time, Judge.
No, Your Honor.
Thank you.
You have a good weekend.
Thank
Thank
you.
you, Your Honor.
You too, Judge. Take care.
Thank you.
Court officer, we had the same problem last time. It's off, they're just waiting for somebody from the road to free up to go.
Like today,
I was told he'd be brought today.
Mr. Black, at an undisclosed time period from Genesee County. Because they don't do, but they're gonna put them on.
I hope he was supposed to go get him,
Okay, sounds good.
somebody from the road.
Well, we'll see. Well, what does Mr. Goodrich have to do later? He might be tied up.
I mean, same time this morning, I can certainly make it work. This afternoon's gonna be much more difficult.
It sounds like we don't know what time LPD's planning to go get him. Tell LPD we might have to reset it and they have to ensure they're gonna go get him because we can't just,
We'll make it work. It's not a complicated sentencing.
well, what if
I'll
they
get
don't go?
somebody from my
Oh,
office.
someone else from your office could potentially cover?
Yeah.
Okay, that works. then.
Oh.
Well, we'll hang on to that file until,
But Carter is downstairs.
okay, Carter's an exam. Are we running that?
Carter, yes, that is an exam that we started and we're to continue today. And Mr. Carter was brought here from the Egaly County. He is in.
Carter. Ready to go on the record on Edwards? Can we go on the record for Edwards?
Not yet. Mr. Stevens is speaking with the on that.
Okay.
One member.
Sounds good.
Want to proceed.
Sure, Jeff. You're 100%.
Is it Amy Lockwood?
Yes.
Okay. Do you have a case number?
A friend of mine has a court case at 9:30 and I wanted to watch,
Who's a friend of yours?
John Kane.
Oh, okay. No one's allowed in the virtual courtroom, which is where you are, unless they actually have a case. If you want to watch
I'm
it though,
sorry.
you're fine. If you want to watch it, we are live on YouTube.
Okay, I will join the YouTube. Thank you. I'm so sorry.
Oh, you're fine. Thank you.
Yep.
Okay, we're on the record in the matter of the people of the state of Michigan versus William Carter. File number is 23-01126 FY. Appearances for the record.
Sage Castleman on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Carter, who's standing to my right.
Okay, today was the date and the time that we continued the preliminary examination that began back on April 27th, so that subpoenas could properly go out for the with other witnesses. Are we ready to proceed at this time?
Yes, Your Honor.
Yes, Joe.
Okay, any preliminary matters?
We do plan on going forward with at least one of the officers under the MCL 768.27C rule. Just want to give the court a heads up, and I didn't let Mr. Goodrich know of that.
There may be objections depending on the questions and stuff regarding that issue.
Oh, sounds good. Any other preliminary matters?
No, Your Honor.
Okay, you can proceed.
All right, I would be calling Officer Mikhail Cook.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. Can have a seat, officer. There's a microphone in front of you and then my court reporter is behind you. So we want to make sure that she can hear your responses. You do have a softer voice, it appears.
Okay.
Okay, thank you. Can you state your first and last name and spell them both?
Yes. First name is Mikhail, Mikal. Last name Cook, Cook.
Thank you. Proceed.
Where are you currently employed?
At the Lansing Police Department.
Right, and what's your position there?
I'm a police officer.
Okay. And were you on duty on April 8th of 2023?
Yes.
What was your shift that day?
The night shift.
Okay. And was there any type of incident you were dispatched to around the location of King Boulevard?
Yes, we got dispatched to an unknown trouble of a female in the car screaming and telling us to get to another address, 5515 South.
And what city is that in?
Lansing, County.
Okay. And when you got there, what happened?
The initial contact, we got there, we could see a vehicle that was with its hazard on parked incorrectly. No one was in a vehicle. As we were approaching the address that we were told to go to, we could hear a male and female screaming and arguing. We tried to make contact with the door, but no one came to the door.
Okay. And could you hear anything in terms of what they were saying, screaming or arguing?
No.
And what happened next?
Later on, approximately 3 in the morning, we got another call, a return trip to go back to that address.
So when were you first there at the address?
When we got the first call
Yes.
about the female screaming in the car.
Yeah.
Like what time?
So you said that you returned back to the address.
Yes.
At some point. So when were you there first?
I don't know the exact time of that first call.
Okay. Was it like hours before, minutes before?
I'm not sure.
Okay. And you went back to the residence.
Correct.
And what happened then?
We went back to the residence and basically just checked the welfare. We had got another unknown trouble from that address. As we approached, a male came to the door and he asked why we were back at the address. We told him that we needed to check him and the female's welfare. At that time, we had that female on the line with dispatch. He continued to try to tell us that he was okay, but the female still wasn't coming to the door, and he said that she didn't want to speak to us. We can hear kind of like him blocking or moving around or something. We were going on behind the door because he was blocking the door. We continued to ask if we can speak to the female, and he continued to tell us that she was okay and didn't want to speak to us. At that time, we got word from dispatch that she was telling us not to leave and that she was not being allowed to come to the door.
And what happened next after that, during that situation?
At that point, she was advising that she was being held hostage. So one of our officers attempted to kick in the door. Eventually, someone did come to the door as he was kicking the door in. They opened the door slightly. As the door opened it slightly, we at that point tried to make our way in. We made contact with the female victim, Tia Austin, and I think her daughter was right next to her. We asked her if she was okay, and she looked at us, shook her head no, and we got her daughter out. Then her son eventually came out right after, and we made contact with the accused and arrested him as well.
Okay. And tell me all about her demeanor when you made contact with Miss Austin.
Initially, she was very frightened. She was afraid. She wasn't really talking. That's why we asked her if she was okay. She verbally shook her head no.
Okay. Did you notice anything about how her body was moving or any type of indicators of her demeanor on her body?
Just kind of still.
What was her demeanor like when she got kind of away from the
She was
residence?
very shooken up and emotional.
And when you're saying shooken up, what do you mean by that?
Like she was afraid. At first, she was not really talking to us, wanting to tell us what was happening. And then she was talking to another officer at first, when trying to get a statement for her from her, and she wasn't really explaining what was happening. She was kind of crying, not kind of, she was crying. And again, just seemed very frightened. And then I went back to talk to her, and then she finally gave me a statement.
And where was the statement given in relation to
In a
this?
patrol vehicle.
Okay. And so that was on scene?
Yes, correct.
All right. And when she was making that statement to her, was her demeanor the same, shooken up and emotional?
Yes.
And in her statement, did she indicate who she was giving the statement about, like her relation to that person?
Yes, it was her boyfriend, the accused, named Carter.
So at this point, I'm going to ask if the statements may be testified to under the MCL 768.27C rule.
No, we would object to that, and that rule does require that the statements indicate to have be trustworthy. We previously had Ms. Alston testify in this courtroom that she was basically had a motive to lie about that, and that she had she was basically cheating on her boyfriend with another man who was at the gentleman's club there. She stated that all the statements that she was making to the officer, many of them were untrue. She stated that after reviewing a police report, that she thought that many of her statements were mischaracterized. So I believe that there's just a lack of trustworthiness here that would allow for any testimony regarding her statements from 768.27C, Your Honor. Thank you.
Did you want to respond to the objection?
Yes, so I do think that the elements of MCL 768.27C are met. It does not require unavailability of the witness. I know the witness testified previously in a hearing that I was not a part of. I do think credibility is a determination obviously left up to your honor in this matter. I think that her demeanor and the actual kind of being outside the door where this situation was happening, getting dispatches, there is extraneous evidence that corroborates in terms of the victim's initial statement. And I think that credibility needs to be determined by the judge in this matter, the fact finder. And just because there is an issue in terms of a victim possibly recanting on the stand and going back on what she said initially, unlike the testimony that was likely presented in court, this statement to the officer was accompanied by actual demeanor, crying, frightened. It was made immediately after the incident, or pretty much during the incident that happened. And I think that the court should hear this properly under the rule and can make a determination in terms of credibility. It does not need to be 100% certainty to allow this type of statement under this court rule. So I do think all the other elements have been met as well.
In response, Your Honor, while testimony, she has already testified that she was very emotional at that time, and the evening that she was interviewing her, and statements in that situation are often not as accurate as what she would state under oath in front of Your Honor, as she did on April 27th. She testified under oath, under penalty of perjury, as to essentially the inaccuracy of the statements that she made on that night. So we would ask the court to deny any hearsay statements under the statute.
I'm asked whether or not the foundation to admit testimony under MCL 768.27C has been met as to the section regarding the statement's trustworthiness. It says statements were to be made under circumstances that would indicate the statement's trustworthiness. The court did have testimony from Ms. Austin back at the previous hearing on April 27th, at which point she made some statements about why she said or did what she did during that instance. I'm going to defer or my ruling as to the credibility of that until the time that I give my ruling at the end of this examination. I do believe that for the purposes of admitting testimony, hearsay testimony, please I see the foundation has been properly laid, and so the objection is overruled.
So in terms of the state, I guess just one more question about her demeanor. Did you see any signs of intoxication in Miss Austin?
Yeah, I believe her to be intoxicated.
Can you tell me about the level of that based on your training and experience as an officer?
No, I was more concerned about her being in fear at that moment.
Okay. And was she so intoxicated that you couldn't understand her?
No.
And so how did you know that she was intoxicated?
Well, she advised that they just came back from going out, and just from her kind of being a little emotional and slurring her words, but that's about it.
And what did she state to you in the patrol car?
She advised me that she and her boyfriend, accused Carter, went out to the strip club, Centerfold. She said that the accused got into a little altercation with one of the dancers there, and she was trying to intervene to de-escalate the situation because he was on federal parole. And in that time, she said that he kind of turned around, switched, and got upset with her.
Okay, and then what happened then when he got upset?
She said that he tried to leave in her vehicle, and she tried to stop him in the midst of him trying to leave with her vehicle. She was in the driver door, and she grabbed onto the wheel, and he began to drive off. And as he was driving off, he was dragging her. At that point, he grabbed her from the driver's side, pulling her through the car to the passenger side. At that time, that she said that's when she began to call 911, which is reported on the dispatch line. As she was on the phone screaming and hollering, she advised that we needed to get to 5515 South King Boulevard. As she explained to me through that car ride, she advised that while she was on the phone, which again is corroborated by the dispatch call that we listened to, he turned up the music and she would turn it down. He would turn back up the music, and she said what was happening in person was that as she was turning down the music, he was punching her arms and hands to stop the music. You can hear on the dispatch tape him telling her not to touch, using profanity, not to touch the radio as he continued to turn the radio back up. He said, "You really want to do this?" As she explained, when he said that, he began to drive over 100 miles per hour which you can hear the car rev up on the dispatch tape, drive it down. She said at that point, she thought she was gonna die. That's how fast he was driving. She said multiple times during that car ride, 255 South King Boulevard. He told her to get out the car. At one point, as he was driving, he actually did open the door and try to push her out, and she advised that she wouldn't get out her car. And he then sped back up, which made the door close. Eventually, they got back to 55 South King Boulevard, and they continued on with that argument. And he advised her that he was just going to leave, but as they continued on arguing, that's when we showed up, which that's what we heard. But she didn't come to the door at that time because he advised that he was going to leave.
And so that was when the first
call we got for the unknown trouble. The woman screaming in the car, asking us to get to 55 South.
Okay. And what happened after that point, I guess, between that and that call and the second call?
Yep. So he was object, and the victim, continued to argue, and she advised. She said that at that point, he was not leaving, and he was not letting her leave as well. He took the accused keys and would not let her come to the door, so she called her back. As we came back, she said at that moment, he would not allow her to come to the door, which she got back on the phone with dispatch and told dispatch that she was not being allowed to come talk to us.
Okay. And so she stated to you that her boyfriend refused, like took her keys.
Yes.
So she was attempting to try to leave the residence.
I don't know if she was trying to leave in her car, but she just advised that he took the keys. Okay. So I don't know if it was an argument that they were having over the keys. She wasn't kind of clear on that, just the fact that they're arguing and she wasn't allowed to go to the door.
Okay. And in terms of that situation, how was she trying to go to the door?
I'm not sure.
Okay. So how many times did she try to leave the residence?
From what I recall, at least 3 times.
And was he using anything other than his words to kind of prevent her from leaving that residence?
Not that I recall.
Okay. And why couldn't she just, go and open the door? Was there something preventing her from doing that?
Not sure.
Okay. Do you recall stating anything in your report or writing a report about this incident?
Yes.
And is there anything in your report that you could refresh your memory with in terms of what was preventing her from going outside the door?
I can check my report.
Okay. Do you think that would refresh your memory?
Yes.
Okay. So I just ask that you refer to your report, and then I can re-ask you the question. Have you refreshed your memory?
Yes.
Okay. Can you tell me about what she stated about what was preventing her from going out the door?
She advised that she actually went down to the door to try to leave, and he prevented her from leaving.
Okay. And did she say anything about advising dispatch that she was not able to leave?
Yes.
What did she say about that?
She told dispatch that do not let the officers leave, that he's not allowing me to come to the door.
Okay. And did you observe any injuries on the victim?
Yes, she had some minor abrasions and bruises on her hand and arm.
Did she explain to you where those were from?
Yes, from when she was being punched when trying to turn down the radio when she was on the phone with 911.
Okay. All right, I don't have any further questions for this one.
Cross-examination.
Officer,
by the time you arrived on scene, you didn't see anything that went on in that car. Is that correct? Between the two, between Miss Alston and Mr. Carter, you never saw them in a car together.
No, the car was unoccupied.
When you arrive on the outside of the house, can you see anything that's going on inside the house?
I can see movement in the upstairs bedroom, but couldn't see exactly what was going on.
Okay, so everything you're going off of is just kind of what you heard after the fact, correct?
When we first arrived to the house, you can hear them arguing.
So you could hear an argument, but you couldn't see anything physical, any
No.
blocking the door, anything along those lines.
Not inside the house.
When Mr. Carter first opened the door crack there,
Mhm.
you know, we're talking about a foot or something like that.
Yeah.
Was Miss Alston anywhere nearby trying to get through the door? Could you see her?
No, I could not see her.
Okay, so she didn't appear to be around the door trying to leave at that point?
No, I didn't know where she was.
When you spoke with Miss Alston, initially she didn't want to make any statement to you, correct?
Correct.
And it wasn't until you actually put her in the back seat of your patrol car and essentially where she felt unable to leave that she would actually make a statement, correct?
No, this all happened in the back of the patrol car. Once we got her out of the house, she was already placed in the back of the patrol car. And
Okay.
then when speaking to her, she specifically advised that she was afraid to talk because of retaliation of his family.
But she was, like I said, she was in the back of a patrol car. She didn't make any statements until she had been put there, correct?
No, she was automatically put there. I'm guessing you're confused. She was taken out of the residence, then automatically put in a patrol car.
And she was concerned about what was happening with her children at that time as well?
Yeah, because one of her kids got detained.
And why was he detained?
Because he was confused on what was happening and he got irate and aggressive with one of the officers, so we detained him for the time being.
Okay, and did he make any statements to back up her allegations that she told you?
Not from him, I didn't speak to him.
And when you spoke with her in the back of the car, did she also inform you, I believe she informed you that prior to calling that second time that Mr. Carter was packing things to leave, is that correct?
Yes.
So if, I guess, I don't understand the disconnect here. If she was unable to leave, why, if Mr. Carter was planning to leave, why was she unable to leave? Couldn't she have waited, or I don't understand the disconnect in your report here.
So the first time she advised that the reason why they never came to the door was because he started to advise that he was gonna pack up and leave. That's why we didn't get an answer at the door. We just heard the arguing. The second time she advised that some key situation, he couldn't find some things, that whatever the specifics are, I don't have those, what he was looking for, what he couldn't find. But he was not leaving, the argument continued, and that's why we got called back. Because he was not leaving, and at that point, he was not letting her leave.
Now, she was also complaining that Mr. Carter took the keys so that she couldn't leave or anything. Did you ever find, were you in charge of looking for the keys at all? Or?
No, I don't recall if he ever actually took keys. It was just he couldn't find certain items or.
Right, but that was part of what Miss Alston was upset about.
Yeah.
And she stated that she was intoxicated as well.
I appeared so, yeah.
And did she require any type of medical attention at all?
No.
For anything that had happened?
No, sir.
Even like being drugged out of a car didn't require any type of medical attention?
Nope.
No further questions, Your Honor.
So was there another officer that tried to get a statement from the victim?
Yes.
Okay, and who was that officer?
Officer Kendall.
Right, I don't have any further questions.
Can I choose witness from the stand, but not from the building yet? Are you gonna call another witness?
Yes.
Okay.
So I would be calling Officer Sager Candell. He can-
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat, officer. Please state your first and last name and spell both of them.
First name is Sagar, last name is Campbell, spelled Sagarkandel.
You can proceed, Quentin.
All right, officer, where are you currently employed?
Currently employed with the city of Lansing Police Department.
All right, what's your position there?
My current position is a road patrol officer.
Okay, and were you on duty on April 8th of 2023?
I was,
And was that a night shift that day?
it was,
Or night? Okay. And on that date, were you dispatched to a location around King Street
or
King Boulevard, sorry? And why were you dispatched there?
I got dispatched there. It was a weekly call for Silver Stolen Apartments for an unknown trouble where there was a female that had called and there was an open line and dispatched could hear her screaming in the background.
Okay. And were you there by yourself as just one officer, or were there other officers with you?
Nope, I got there for the second call and there were several officers out there inside the city.
And what was decided to be done?
When we got there, the other officers that were there for the first time as well, and they advised me that the male that was inside would not open the door, and we were trying to make sure the female that had called was okay. And as we're still outside, dispatch still had an open line with the female, and dispatch advised that the female was being held hostage, and at that point we started to make forceful entry inside the residence to make sure that the female was all right. And as we're doing that, the door propped open and we're able to get the door open before we go inside.
And was it before the forced entry, was there any conversation with anyone behind the door?
Yeah, it was with a male voice that was refusing to open the door. I remember letting that male know that we was trying to make sure the female was okay, and we had to make sure it was all right.
Did he make any statements about refusing to open that door?
Yeah, at some point I recall the male asking for us to get a search warrant, but due to the female still being an open line and dispatch advising that she's being held hostage, we got an entry had to be made to make sure she was okay.
Okay, and then,
I'm gonna ask that you keep your voice up because it's trailing off at the end and I'm struggling to hear you, okay?
Yes.
Thank you.
eventually, were you able to make contact with the female inside?
Yes.
And what happened when you made contact with her?
So once the door opened, she was the first person by the door. She looked visibly shaken. And I asked her if she was okay, and she nodded like no, side to side. And at that point, I believe that she was not okay, and we asked her to come out to a safer environment where other officers were outside, and went from there.
Okay. And once she was brought over to that location, what did you notice about her demeanor?
I noticed that she was scared. She was crying at times, and just shooken up.
And you were the first one to make contact with her out of the officers?
Yeah, I started, I got the initial statement from her.
Okay. And where was that initial statement taken?
It was taken, she was placed in the back still for a police vehicle, just for her safety. And I talked to her while she was sitting in the back seat.
And when she was talking to her, what was her demeanor like?
She continued to be scared, and she was, like I said, she was crying and was tripping up as she was providing the statement.
Did she express any type of fear?
Yes, she had told me that she was in fear for her life, and she was scared of the defendant's family. But that she wouldn't be safe if she gave a statement.
She wouldn't be safe if what?
She wouldn't be safe if she gave a statement.
And so at this point, I would ask if this testimony also would be allowed under MCL 768.27C. I think that, again, the circumstances surrounding this statement were given under the fear of the event that aids to the credibility of the statement. We already had testimony in regards to the victim's injuries at that time. Her demeanor was similar when she talked to the current officer, Sager here, or Candle here, sorry. And I do believe that all of the circumstances allow for admission under MCL 768.27C. These were statements made to a law enforcement officer after a domestic incident. Mr. Goodrich.
Yeah, we would object for the same reasons stated previously, understanding what the court's ruling was, that we would just like to place that objection on the record.
Your objection is noted. I find that the foundation has been properly laid, so testimony can proceed under 27C.
Thank you. So what did the victim state to you?
The victim stated that she was out, I believe at the Centerfold Strip Club in the South End of Lansing with the defendant, and they had gotten some argument regarding the defendant defending another stripper at the strip club, and a verbal argument started, and they had walked out to their vehicle. During that point, the defendant started driving away, and victim advised me that she was still hanging onto the car. And at some point, she was quote unquote snatched inside the car from outside. And they started driving away from that strip club.
She advised what happened when she had called the police.
I'd have to refer to my police report if that's okay with you.
Okay. And I'm specifically asking about the time that she was, I guess, if she called the police when she was in the residence that you responded to.
She did call the police while she was in the residence. I remember one of the dispatch notes being that she was looking for her keys, but I would have to refer to my police report for those statements that she was doing at that point.
Okay, if that would that refresh your memory?
Absolutely.
Okay, and just let me know when your memory's refreshed and I'll re-ask the question. What did she state to you about calling the police if she was in the residence?
So she said that when the police got there the first time, Mr. Carter would not let her out, and he kept telling her to tell the police that everything was okay and she was fine, and that would cause the police to go away.
Okay. And any time did the victim state that she didn't want to talk to the police?
No, she did not.
Did she say anything about that she didn't want to make a statement to you?
So as I was talking to her while she was in the back seat, she expressed that she didn't want to make a statement because she was in fear of Mr. Carter's family, and she asked for a minute to process while she was emotional, and I stopped interviewing her at that point, and Officer Cook had taken over interviewing.
Okay. So at that time, she was too emotional for you to be able to interview her further?
Yes, ma'am. I just wanted to give her a minute to process things.
Okay. All right, I don't have any further questions for this one.
Last exam.
Officer Kendall, Mr. Carter and Miss Alston were not the only people in that apartment, were they?
No,
Who else came out of that apartment?
I recall there's a young juvenile female and juvenile male, I believe, the victim's kids.
And this, what you refer to as a juvenile male, I mean, this is somebody who's somewhere in the 17 to 20 years old range, is that fair?
Correct.
And do you recall roughly how tall he was?
Roughly, I would say about 5'6", 5'7".
Right, so 5'6", 5'6". I
He
mean,
was-
he
he was
was
about my
taller.
height.
He was taller than almost all the officers there, wasn't he?
I don't recall the exact height,
Okay.
but yeah.
But he's a big guy. In fact, didn't you feel the need to detain him?
Yeah, we wanted to get everybody out of the house.
Yeah, but you actually put handcuffs on this young man, correct?
We did.
And was that out of safety for the officers because he's a pretty large individual?
It was out of safety, and I recall that he would try to go back to the house when we were trying to tell him to not to go back to the house, and based on that uncooperative.
And he was very angry that you were there, correct?
Correct, yes.
And you stated that you had heard a male voice refusing entry to the house, correct?
Correct.
Is it possible that it was actually her son who did not want the police there?
Could be possible, yes.
Okay. And he was right near the door too when you guys finally entered?
Yes, sir.
And he was probably the most aggressive toward the police at that time of any of the four people?
Correct.
You stated, okay, so you also got to see Miss Alston quite a bit, obviously, as you led her out to the car, correct?
Yes, sir.
Did she have any like wounds or injuries consistent with getting drugged by a vehicle as alleged?
I did not see any injuries. It was dark, and someone else placed her in the backseat of her police vehicle. And
But you sat right next to her in the back, right?
I stood outside the car, yes.
Okay. So you got a good look at her.
Yeah, that's her face.
Did you see any torn clothing, anything like that?
Not that I recall.
And after briefly speaking with her, she made it clear she didn't want to talk to you any further, correct?
She was very emotional. She, like I said, she was crying through my interview and expressed fear that, if she had to talk to me further or gave a statement, she wouldn't be safe. So I gave her a little bit of time to process it.
Okay. Did Miss Alston appear to be intoxicated to you?
Not that I recall.
No further questions, Your Honor.
Direct.
Yes, did you see Mr. Carter near the door when you entered?
Yes.
Okay, and do you see Mr. Carter in the courtroom today?
I do.
Okay, can you just tell me where he's sitting and what he's wearing?
Standing, sitting all the way to the left, there, wearing orange jumpsuit.
Did you end up arresting Mr. Carter?
We did.
Okay, Did he make any statements on whether he was near the door or anything of that nature?
I did not get a statement. I believe Officer Traverso had the most contact with him.
I don't have any further questions at this time.
Please, excuse me, stand. Thank you. Call your next witness.
I may have one quick witness or I may not. The people would, I guess, rest us feeling for this time. I don't have any further witnesses.
Friends calling any witnesses?
We are not calling any witnesses, Your Honor.
Okay, I need to go off the record for a moment. Mr. Smith?
Good morning, Your Honor. Ms. Skalapski was having trouble getting her video feed up and running. Her computer was telling her that it says the host has disabled her video feed.
I did because she appeared early. Let me bring her back.
Okay, I'll jump back in the breakout room. Thanks for the help.
No problem. Let me see if I can get her started now. Okay, there she goes. If you both want to return to breakout room, you can conduct your debtor's exam there.
Okay, thank you so much.
back on the record. Appears the court received a letter, date stamped for yesterday, 3:34 p.m. Allegedly from a Tia Austin. Get a copy for both of you all. And counsel, you can proceed to argument whenever you're ready.
So Your Honor, I do believe that the elements for unlawful imprisonment have been met here. The other two counts are misdemeanors in this matter. I understand that the victim did testify in this matter and that she clearly recanted on the stand, clearly stated that she was lying to the officers. And in addition, there is this letter that seems to go over additional reasons as to why she states she was lying. I don't believe that any of that letter is under oath, nor can I verify that it was actually Miss Alston that sent that letter, but I appreciate the court giving us each a copy of that letter for our own records. I do think this matter Well, clearly the victim came onto the stand at the last hearing and recanted. There is clearly a conflict of facts here. There's clearly a question for the jury in terms of what actually happened here. There is a conflict of evidence in terms of there may be reasonable doubt in the court's mind, or there may not be, but any of those questions should be left up to the jury for trial in this matter. I think that the statements by the police are backed up by actual extraneous evidence, such as the victim's demeanor, the fact that they could hear a male behind the door, supposedly Mr. Carter refusing to open it. They had to come back twice to actually get the door open at that point. They did not have exigent circumstances at the first time to knock the door down, but at the second point, the victim was conversing with 911 and stating she was being held hostage. I think it's clear as to why the victim recanted in terms of her statement to the initial statement to the police, that she was afraid to give the statement. She was worried that his family was very dangerous and that she was scared. She was crying throughout that time. She was too emotional to even give a statement to the first officer. And to the second officer, she was able to give a more clear statement, and she was observed with injuries on her person. That's not necessary for the account of unlawful imprisonment, but I do think it was clear that she was restrained within the house. She doesn't need to be physically restrained, but he was preventing her from leaving, and she was secretly confined within that house. And clearly the defendant did not want to let the police in and didn't want them to know what was going on or what had happened before that unlawful imprisonment occurred. So I do believe that there's a conflict of evidence here. And even if the court does have some reasonable doubt of the defendant's guilt, that is not required for bind over at prelim. And I believe that the statements of the police are far more credible than the statements of the victim in this matter. But of course, the court is the one who determines what they believe in terms of credibility. Thank you.
I have a question though, because unlawful imprisonment requires you to select one of the bases upon which the unlawful imprisonment was committed. And so what is the theory as to?
I believe it would be the circumstance B under the jury instruction that the restrained person was secretly confined, meaning to keep the confinement or location of the restrained person a secret. I believe that was the intention here, and that was what he was charged under in terms of keeping Miss Alston within the residence and not allowing her to be discovered by the police or to come to the door. I think that that's clearly secretly confining her and restraining her at the residence.
Rich.
Your Honor, on one hand, the prosecutor asks you to find that Ms. Alston committed perjury every step of the way, basically every question that she answered 5 weeks ago. And on the other hand, they want you to believe statements that she made to police on the night 2 months ago. Ms. Alston testified very clearly in this matter. She stated that she had gone to Centerfolds with a young man by the name of Troy. She got into an incident with him in the car driving back. She testified that when she got home, she was intoxicated, and based on her infidelity, that Mr. Carter was packing his belongings to leave, which was something verified by some of the officers testifying to that. So she told them as well that he had been packing his things to leave. She testified that as a way to try to keep him from leaving, as she had just recently become pregnant as well. She panicked, called the police, and then once she was put in the back of the car, she told officers what they wanted to hear so that she would be let out of the car essentially. Shortly after this, so this incident, it was alleged to have occurred on April the 8th. April 12th, she contacts LPD stating that she wants to make another statement on the matter. I believe on the 13th, the LPD calls her back and does actually a second interview that Ms. Alston testified to, that she essentially recanted everything that she stated, stating that what she had told the police was untrue, and that Mr. Carter had never falsely imprisoned her, had never assaulted her, had never driven recklessly or done any of the things that he is accused of in this case. Shortly after that, she gets a notice from the prosecutor's office victim witness unit. She testified that she sent this in. It's dated the April 19th. Again, telling the prosecutor's office that what she had claimed that night was untrue, that Mr. Carter had never falsely imprisoned her, that he had never struck her, that she had essentially lied about this in an effort to keep him from moving out of the residence at that time. While this is not in evidence, it's also my understanding that she's since had a hearing in a federal courtroom regarding this, as Mr. Carter is on federal probation regarding this, and she testified the same way there as she did here, is my understanding. We have also heard in this case, well, one thing we did not hear was any video evidence from like centerfolds showing that the two of them were actually there. They didn't appear to make any effort to get such video. None of the officers saw what was going on inside the house. Officer Candle testified that while it was a male's voice, and it could have actually been her son who was yelling at the door, and he was actually the one at the door who was essentially being belligerent with the officers, and the fact that they had to take him well, they had to detain him, I guess is the legal phrase that they use, that they handcuffed him. If Miss Alston, again, was that terrified of Mr. Carter, who himself is not a large individual, I'm sure her son, who's appeared to be college age, somewhere around there, late high school, college age, certainly would have been able to at least help her get out of that place. But again, that is her testimony that she was never falsely imprisoned. She was never held there. They're arguing that on the basis that he was keeping there secretly, even though the officers are also claiming she claimed that over the phone, that while they're driving back to the apartment, she called the officers regarding what he's doing. She called the officers, I think it was 2 more times while at the apartment. Certainly, it's not a secret that she's there. I mean, I don't know how they can seriously argue that he's somehow keeping it secret when she continues to talk to the police. She's on the phone with the police this entire time. It's certainly not a secret. Your Honor, I think what we have here is a domestic situation brought on by Miss, Alston, like I said, infidelity, which led to a bigger argument. And due to her intoxication at that night, I believe that is the least credible of all the statements she's made. She's been nothing but consistent since that night, since she's become sober. And again, she has essentially risked perjury, not only in this court, but in a federal court, to tell the truth of what happened that night. So, Your Honor, we would ask you to deny the bind over in this case, as there's just no viable evidence. And it appears to be, if the court notices, Mr. Carter is in federal custody at the moment on a probation violation for this incident. So essentially, he's being held indefinitely on a case in which there's virtually zero chance of there ever being a conviction. So we would ask you to deny the bind over in this case. Thank you.
Today was the date set to complete the preliminary examination, which began back on April 27th. Mr. Part of the purpose of the preliminary examination is for the prosecution to meet their burden, which is to establish that they have sufficient probable cause. That's probable cause that a crime was committed, and probable cause sufficient to charge you with the crime. And so this is not a trial. The time of trial, that's when they address the standard of proving each element of the charges being brought against you beyond a reasonable doubt. Today is a very low burden. It's more than mere suspicion that a crime was committed. And I'm the sole determiner of the credibility of the witnesses at the time of the examination. We had testimony back on April 27th of Ms. Tia Austin. And at the time of the testimony, it was established that back on or about April 8th, 2023 at the area of 5515 South MLK, City of Lansing County, State of Michigan, that there was some incident that occurred. While on the stand, I would I noticed the posture first of Ms. Austin. And she is what I would term as a hostile witness. She had to be directed to answer certain questions. She had to be reminded from the very beginning of, or have her recollection refreshed about very simple things such as, did you call the police? She became argumentative just at that question right there. She didn't recall. Then she went to, when asked if her recollection could be refreshed, she became argumentative. I had to advise her, she had to answer the question. She told the court that she doesn't recall much of the incident because she was drunk, and then she later told the court that she suffers from memory loss. The court does not believe Ms. Austin to be a credible witness. Not because the court believes that she may be intentionally evading or changing facts, but based on her own statement under her oath, she doesn't remember she was drunk and or she has memory loss. So she wouldn't be a credible witness as to what she said or what could have happened then. Maybe she remembered then she wouldn't remember 6 weeks later. I don't know. But what we do have though was testimony presented today under MCL 768.27C of 2 officers that testify as to a dispatch involving a domestic violence call. I think there was multiple dispatches that happened that night. And as a result, we have the defendant being charged in count 1. It's an unlawful imprisonment at or near 5515 South Martin Luther King Boulevard. And then there's a domestic violence and a reckless driving, which does not need to be addressed as it relates to probable cause. The jury instruction for unlawful imprisonment requires that at the time of trial, that the people prove beyond a reasonable doubt the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movement or to forcibly confine a person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to the commission of other criminal acts. Second, the people will need to prove that the defendant did so under one or more of the following circumstances. A, the person is restrained by means of weapon or a dangerous instrument. B, the restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. The person was restrained to facilitate the commission of another felony or to facilitate flight after commission of another felony. I had testimony from Ms. Austin, but then also from Officer Cook and then Officer Candle. And both Officer Candle and Officer Cook and even Ms. Austin, even reluctantly, they give testimony of a call made to, or calls made to 911, in which dispatch was provided an address as to where to meet the alleged victim, who at the time originally was in a vehicle and indicated she was being transported and that the officer should meet her at 5515 South MLK. There was testimony from Officer Cook that even while the officers were at the address and trying to make contact, it looks like the officers appeared the first time, no one answered, and then the officers left, but they came back because there was another call to that same address that when officers approached, the person that Officer Cook identified as a defendant opened the door, and she testified that she could hear what she believed a male or some blocking to be doing at the, I don't know if she said a male, but she believed there to be some blocking of the door, indicating that they couldn't gain access, and that they were asking to check on both the male subject and the alleged victim is Austin, and that the male subject indicated that they were fine and that she didn't want to come to the door. And at one point, I think Officer Campbell testified that there was a request or a statement made by the male subject that he identified as the defendant that they needed to get a warrant if they wanted to gain entry into the home. Officer Cook testified that while they were speaking to the defendant at the door, that dispatch was advising that apparently the victim was still on the phone with dispatch throughout this interaction, telling the officers not to leave, at which point the officers kicked the door in and made contact with the victim. Based on all the testimony I have here before me, I don't believe that there is enough to support that there was a restraining that was secretly confined, or that the confinement or location of the restrained person was a secret, because it was very clear where the victim would be. Victim called the police. Looks like the victim was on the phone the entire time with dispatch. Doesn't even appear that the defendant tried to take, or alleged there was no allegation he tried to take the phone and tried to prevent her from making any calls to 911. Only prevented entry into the home, which it appears it was his home, and he has a right to deny entry into his home. So based on the lack of sufficient evidence to support probable cause, count one will not be bound over to the circuit court. Count two is domestic violence. Count two is reckless driving. Those do not need to address probable cause, and so those will continue to a pre-trial. Count one will be dismissed. Pre-trial will be June 26th at 10 o'clock in the morning. And so we likely need to get a writ for that, correct? He's being held, he said, on a location.
In Newaygo County.
Okay.
I don't know if it'll be resolved based on today or not.
Okay, sounds good. Bond was set at 5,000 cash surety. There is a no contact order that will continue as to the alleged victim, Tia Austin. You're still not to be within 2,000 feet of wherever she lives, works, or goes to school. There's not to be any contact directly or indirectly with this Austin. Do you understand that, sir? Okay, do you have any questions about the ruling and or your bond conditions at this time? No. Any additional matters for the record, counsel?
No, thank you.
No, Your Honor, thank you.
You're all set, sir.
Thank you, Your Honor.
Mr. Smith.
Morning, Your Honor.
Okay. Okay, Mr. Smith, were you able to complete your exam?
Yes, Your Honor. The Q&A part of the creditor examination is complete. There are some documents, though, that are responsive to your subpoena involving employment, certain banking information, registration of certain vehicles. I'll send her a letter reminding her of exactly what she needs to get to me. She thought in the next 14 to 30 days she could do that. I don't see a need for any type of control date or follow-up date from the court. If I don't see those documents, I'll simply file a motion to show cause. More importantly, though, I think we figured out a way to retire the judgment. She's agreed to a wage assignment through her current employer. She gets paid biweekly and has agreed to a $75 per pay period wage assignment that I'd simply like to put on the record at this time. That way I can prepare and submit straight to the court.
You can proceed.
Miss, is it Sklapski?
Yes,
Okay.
yes,
You and I discussed where you're currently employed. You've been there since September of 21, correct?
correct.
All right, and we had a discussion about entering into a wage assignment versus a wage garnishment, as that would better fit your current ability to pay, correct?
Correct.
You thought with your current budgeting restraints as it relates to your income and monthly expenses at $75 per pay period would fit your current ability to pay, and you would like to enter into that assignment through your current employer, correct?
Yes, correct.
Thank you, Your Honor. Nothing further.
Thank you. Do you have any questions today, Ms. Glassby?
No, I do not.
Okay, that's noted here on the record, as indicated by you, Mr. Smith, there's no need for any further control data at this time, so that we're all set and we'll get any necessary documents from you once it's completed, Mr. Smith.
Thank you so much. Thank you as well, Mariah. Appreciate your help.
Thank you.
Have a great day.
Have a good one.
You too. Bye-bye.
On the record in the matter, the people of the state of Michigan, we don't have a prosecutor. Okay, on the record in the matter of the people of the state of Michigan versus Brandon Egaly, file number 23-00850 FY. Appearances for the record.
Sage Councilman on behalf of the people, sorry. Thank you.
Thank you. Toby White on behalf of Mr. Gaylor. He is with me at council table.
Thank you. Today was the date and the time that was set for preliminary examination. My understanding is that there is an unconditional waiver to the circuit court. Is that correct, counsel?
Correct.
Yeah, there's an additional term to that, and that they're holding open an offer of a reduction to home invasion third restitution.
Is that correct, counsel?
I am just gonna trust your word on that. I'm not sure.
Yeah. You said home invasion third?
Yeah.
Okay, I do have, I know the form that's signed. Mr. Gaylor, to understand that you have the right to have a preliminary examination in this matter here in the district court.
Yes, ma'am.
You understand the purpose of the examination is for you to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
Do you wish to unconditionally waive your right to examination today? Okay, sure. Because your voice dropped a little low.
Sorry, I'm just nervous.
That's normal. Just want to make sure you're sure, because it's an unconditional waiver. You can't change your mind after this case is bound over. You understand that? Okay, and you signed this document here? Okay. Anybody make any promises to you to get you to want to waive your right to an examination?
No, ma'am.
Has there been any threats made to you in exchange for you waiving your examination?
No,
So you're waiving it freely and voluntarily?
yes.
Your bind over date's gonna be June 14th. You do not need to appear in court June 14th. That's the date the circuit court will get the file from this court, okay?
Okay.
Your next court date will be a pre-trial in circuit court. Mr. White will be made aware of that date. You remain in contact with him, okay?
Okay.
You still have the address in Windsor?
Yes, ma'am.
Okay, any updates or changes to your contact information, you need to make sure you provide that to the court and to your attorney immediately, okay?
Yes, ma'am.
Bond was set at 3,000 personal recognizance. That will continue. Any additional matters for the record today?
No, thank you, Your Honor.
Nothing further. Thank you, Your Honor.
Thank you. You're all set.
Where did it go as well on Edwards, Your Honor?
On the record in the matter of the people of the state of Michigan versus Darnell Thomas.
Oh, okay.
File number 22-00558FY, council appearance. Who's your attorney? Okay. Yes. Okay, you got an exam to run to?
I have 3 in front of District Court.
Okay,
My
so-
apologies, Your Honor.
No worries.
No problem.
Today was the date and time set for an examination, and my understanding is that there is a nollie. People are moving to dismiss this case because the necessary witnesses have failed to appear. Is that correct?
That is correct, Your Honor. The people have subpoenaed witnesses. However, both the complaining victim and the officer in this case have failed to appear, so people are unable to proceed at this time.
I feel like we've been here before, have we not?
Yeah, Your Honor. Yes, Your Honor.
I thought I was having deja vu.
Please.
Okay.
So the defense would move to dismiss, Your Honor. Thank you.
Okay, I'm sorry.
Defense would move to dismiss, Your Honor. Thank you.
Okay, well, they're moving to dismiss, but it's without prejudice, so that just means they'd be able to reissue it against your client. Did you advise that to your client?
Yes, Your Honor.
Okay, so the case will be dismissed. We'll get you a copy of your dismissal, okay, sir?
Thank you, Your Honor.
No problem.
Yeah. Just 1 second. Your Honor. Hey, I'll be back. All right, bye.
Mr. Richardson. Okay, well, we ready on Price?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Hannah Janelle Price, file number 23-00945FY. Council appearance.
Jeff Broadus on behalf of the people, Your Honor.
Good morning, Your Honor. Melissa Patrick on behalf of Hannah Price, who is here to my right.
Today was the date and the time that was set for preliminary examination. How are we proceeding?
Yes, Your Honor, at this time, the people, we have made an offer to the defense, and that would be for the defendant to plea to an added count 2 of domestic violence with a killabrew for no upfront jail, and request that probation require the defendant to attend parenting classes. However, after conversations with the defense, it is my understanding that the defendant has chosen not to accept that deal. So at this time, the people would seek to add count 2 to this charge, which would be, or to this complaint, which would be domestic violence second. It's a 1-year misdemeanor.
Do we have an exam?
No, we're going to dismiss count 1 with the
Okay.
addition of the added count 2 DV second.
You want to add a count 2 of domestic violence and dismiss count 1, correct?
Yes, Your Honor, with, like I said, the sentencing domestic violence second.
You said domestic violence second?
Yes, there's a
Okay.
previous domestic violence, I believe, was dismissed under 76948.
That is a correct statement, and I will read it to the court's discretion as to the burden that's required for those charges.
Motion is granted. Will allow you to amend your complaint to add account 2 of domestic violence, second, dismiss count 1. We'll set it for a pretrial right now. Well, I don't know if you guys need another pretrial because that seems to have been the offer. So do we want to set it for final pretrial and jury trial?
That will work. Jury trial will be August 7th.
Jury trial?
at 8 p.m.
That work for you, Ms. Patrick?
I didn't quite hear it, I'm sorry.
August 7th
For,
for the jury trial? When's the final pretrial?
that works for me, yes. Your final pretrial, July 24th at 8 a.m.
July 24th for final pretrial.
Let me see. That will work. I'll be in this court anyway.
Okay, no, so July 24th, 8 o'clock in the morning in person at the court, and then August 7th, 8 o'clock in the morning in person at the court. Do you have any questions today, Ms. Price?
No, I do not.
Okay. Bond will continue as set, which is 1,000 personal recognizance. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set.
Have a good afternoon, Your Honor.
Thank you. And we're ready with Mr. Edwards.
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747. Yeah, take a look.
Jeff Roberts on behalf of the people, Your Honor.
Mr. Edwards, you're representing yourself, correct, sir?
Yes, ma'am.
Today was the date and time set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor. At this time, the people have subpoenaed witnesses. Those witnesses did appear, however, after conversations with those witnesses, I believe the people would be unable to meet their burden at this time, so the people are unable to proceed. I would leave to the
You're unable to meet your burden, and so what are you going to do?
people would, if the court prayers, people would seek to dismiss this case at this time.
Motion to dismiss is granted. You have any questions, sir? I can't hear you.
No, ma'am.
Thank you. We'll get you a copy of the dismissal. You can have a seat.
Thank you.
Still on Mr. Black, huh? Who else do we have?
Mr. Lucas here, Mr. Goodrich said that.
Have a parent. Did we get one? So if I was defender's office. And Woods. That you just did that. Uh-oh. Good job. No one else has to do that.
I think I wrote it. No. I checked
Said
the
no.
other day, yeah.
On the 30th, it says that we had not received appearance. On 30th, you said you had not received an appearance.
Yeah, but when I looked on the record, it was, I think. He was supposed to be sending in his appearance, he just never had.
We got an appearance. You should say it on the record. They gotta commit to it. Just waiting for others to come in. Well, you know, blue screen of death. We need a prosecutor.
I think that was the longest adjournment request I ever heard of for a preliminary exam this morning.
I know. That came from the defense counsel. That was available in October. All right.
You need to secretly get another judge to cover that day now, because that's probably gonna be the most painful hearing to listen to.
I don't know. You know, I had a financial one.
Well, that's what that's gonna be, the day of.
Okay, we're on the record in the matters of the people of the state of Michigan versus Doris Daniel Woods. File numbers 22-03352 and 23-01080. F5 council appearance.
Jeff Broadus on behalf of the people. Your Honor.
Luke Goodrich from the Public Defender's Office, filling in for Derek Etheridge today and representing Mr. Woods in both of these matters.
Okay, great. Did we find out if you had appearances from you? We do not have any appearances from your office. So if we can get those, that'd be great, as we need that to accompany the file. Today was the date and the time that was set for preliminary examinations on both matters. My understanding is that there's an unconditional waiver to the circuit court on both files, correct?
Yes, Your Honor. After conversations with the defense, we have both agreed to unconditionally waive the preliminary exam.
Okay,
That is correct.
thank you. Was there offers extended on these?
There was not.
I'm sorry.
There were no offers extended on
It looks like on April 14th, there was an offer on the file number ended in 3352. Defendant to plead guilty to count 1 felon in possession and 1 count of weapons. It says the offer would expire at the first pretrial in circuit court.
Didn't see that in my notes, but I'm certainly not going to disagree with the court.
Take those up and write all those notes for nothing.
Yeah, I'm certainly not going to disagree with the court as I'm.
Okay, so that's noted in the record. It's in the file that it was offered in was to follow to the first pretrial of the circuit court. I recognize we do have a different prosecutor on the matter. However, that's part of the reason why I require there to be police sheets placed in the file, so that we can keep a record of that. And no offer was extended at this time on file number ending in 1080.
That's correct, Your Honor.
And so, Mr. Wood, do you understand that you have the right to have preliminary examinations in both of these files? You understand the purpose of the preliminary examinations is to require the prosecution to put forth sufficient evidence to establish whether or not they have probable cause. So they have to show that they have sufficient probable cause that a crime was committed and probable cause to charge you with those crimes. You understand that? Okay, and you want to unconditionally waive your right to have those examinations in both of these files today? Anybody threatening you to get you to want to waive your examinations? Has there been any promises made to you in exchange for you waiving your examinations? Okay, and so the waivers you're given are made freely and voluntarily of your own accord? You're making your own decision to waive your exam, sir? Okay, and you understand it's unconditional. You can't change your mind. So you say you want to waive it now, then you go outside to your car and realize you regret it. It's too late. You recognize that? If you need more time to think about it, just say that. Because you don't have to do it today. It's up to you. Yes, what's your responding to? You understand it's unconditional and you're still willing to waive it today? I will go off the record. You need to be further counseled, okay? To talk about it a little further with your attorney and your significant other there, okay?
Jail.
Okay, we'll go back on the record.
But we are missing two. Let's see.
Oh,
We need
did?
to.
I don't- why could someone tell the prosecutor he can't just leave? Without, it's the fifth time we have to wait for him today.
Hurting cats, right?
Okay, we're back on the record in the matter of the people of the state of Michigan versus Doris Woods. And I gave you further time to discuss your waiver with your counsel. And do you still wish to waive at this time? Your signed over date's gonna be June 14th. Okay, sir, that's the date that the circuit court will get the file from this court. That's not a date that you need to appear in circuit court, okay? Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that. You stay in communication with your attorney, okay, sir? Still at the address on Balfour? Okay, and if your address changes or your contact information changes, it's your responsibility to update the court in order to be compliant with your bond conditions and to make sure you're receiving all your notices from the court. A bond and file number ending in 1080 with 10,000 personal recognizance, as was the bond and file number ending in 3352. Both of those bonds will continue as set. Any additional matters to the record today?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set, sir.
Your Honor, just off the record, what was the deal that was put on the one?
Defendant to plead guilty to 1 count felon in possession and 1 count weapons.
Okay, the so plead to the CCW and the felon in possession, then you looks like dismiss count 3.
Correct.
Okay,
If there was some emergency, if you were in custody.
and that was open until the first pre-trial insert.
Correct. You might have told the record though, because I don't know if that was a global resolution, because I don't say count 1, which I would say that if it was count 1.
Yeah.
It says 1 count of weapons and then 1 count of felon in possession, which he has in both files.
Okay.
And then we'll say it's then his staff will schedule it. And say, okay, our available
Just
date
not
is
here.
June 28th. So you'll let us know when your pre-trial will be. Okay. As of now, we don't.
So we're just waiting for
Okay. All right. Take care, Mr. Woods.
Mr. Kane, and he has to speak to his client.
Yep, I'm gonna go ahead and move this card.
If he's not able to bring him up, speak to him, we have to bring him up.
Yeah. If you hear anything in black, just email me.
Oh, we just reset it. They haven't freed anybody up, and I don't think it's gonna get any easier in the later in the day.
And it's anybody still, yeah.
the record in the matter of the people of the state of Michigan versus John Kane, file numbers 23-00238 FY, council appearances.
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, David B. Carter Jr. on behalf of John Kane, who is present standing at council table.
Today was the date and the time set for preliminary examination, and then I have a PA 53 violation or multiple PA 53 violations. Here, an offer from the people for the defendant to plead guilty to count 2 of the domestic violence, and the people would dismiss count 1 in the sentencing enhancement. And it looks like they're offering not to proceed on the PA 53, but they can't offer that. It's a contempt of court order. The court has to dismiss that.
And I'm well aware of that, and my client is well aware.
Okay, so you recognize that that's not a part of your offer, the not
Yeah,
to proceed
yeah.
is not, okay. So you want to accept the offer, sir?
Yes.
Okay. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. I have here the rights of rights and the information sheet. It has today's date on it, and that's your signature, correct?
Yes.
You understand each of the rights listed here today?
Yes.
Okay, do you have any questions about those rights?
No, I have an amazing attorney that broke it all down.
I witnessed it, so I believe that you were properly advised, and I don't believe that you would have any questions, but I did want to give the opportunity if you decided at this time that you did have a question. So you don't have a question at this time,
No, ma'am, no question.
and you're willing to waive all the rights listed here in order to accept the offer?
Yes.
Okay. You understand that you're gonna give up your right to a trial in this matter?
Yes.
And so that you're gonna give your right to the presumption of innocence. You're innocent until proven guilty. You have the right to see, hear, or question any other witnesses the prosecution intends to call into a trial. You have the right to call your own witnesses or present evidence at trial that you believe would further a defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. You want to waive each of those rights, correct?
Yes.
You also have the right to have the prosecution prove each element of the charge beyond a reasonable doubt at trial. You want to raise that as well, correct?
Yes.
Okay, anybody threatening you or making any promises to you to get you to want to waive your right and plead guilty to count 2?
No.
Are you currently on probation or parole?
No.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to report a conviction on a future job application.
Yes.
And you understand that a guilty plea can result in a conviction that may have impact on any travel or immigration status that you may be seeking?
Yes.
Okay, and are you pleading guilty because you believe you're guilty?
Yes.
As to count 2 of domestic violence, how do you plead?
Guilty.
On a factual basis.
Thank you. Mr. Kane, on or about November 3rd of 2022, were you with a Miss Morris?
Yes.
And that was an individual whom you had a dating relationship with, correct?
Yes.
And you ended up having a argument with her, is that correct?
Yes.
Things kind of got out of hand and things were thrown, is that correct?
Yes. The TV hit the floor.
Okay. And by throwing that TV, would that have caused a reasonable person to be fearful of being hit, whether directly by it or bouncing off the floor or anything like that?
No, it hit the floor off the stand where it was.
Sure, but it caused her to be in fear of someone, is that correct?
Yes.
All right. And this happened in the city of Lansing, correct?
Yes.
On 5831 Richwood
Yes.
Street, apartment 5.
Yep.
And that's in Ingham County?
Yes.
I have no further questions.
Any questions from the people?
Nothing from the people, Your Honor.
If we're satisfied with the factual basis, I will accept your plea if I can plead be made freely, voluntarily, and intelligently. So that will be set for sentencing July 27th at 8:30. July 27th at 8:30 in the morning. You need to meet with probation so they can provide the court with a pre-sentence report and recommendation as to how you are to be sentenced, okay? Do you have any questions about your sentencing at this time or your sentencing date?
Anyway, they expedited a little bit faster than sitting for another entire month.
No, they require a certain amount of time so they can get the report processed. We'll address your bond in a moment, okay? But do you have any questions about, other than that, other than your bond? Do you have any other questions?
I'm just wondering if, with the sentencing, if there's any way you guys can get me in the bear.
That would be a bond issue.
Sounds good. Okay.
Okay, we'll let you know.
As to bond.
Thank you, Your Honor. Your Honor, my client is obviously has went from a felony down to a 93-day misdemeanor. My client had requested that as a condition of bond, that perhaps if a bed opens up at Bear River, or that you would order him to Bear River, he would like to take the opportunity to deal with some drug issues. And he believes that he'll be able to get into Bear River rather quickly. So we'd ask the court to reinstate bond as a condition of bond to Bear River.
Bond was revoked because of the continuous violations of the GPS tether, but obviously that was during the time in which the defendant was trying to vacate property. The allegation that he was at the property in violation of the no contact order and in violation of the time frame in which the court provided him to be at that property to remove his belongings. I will amend the bonds. I think he does and would benefit from treatment at Bear River. And so the bond, which was originally in place, was a 10,000 personal recognizance with GPS tether. I'll reinstate that bond. With the condition that he receives treatment at Bear River. I'll dismiss the outstanding PA 53s at this time.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
Thank you. You're all set, sir.
Thank you, Your Honor.
You're welcome. That's all we have for today.
Just to check, that was July 27th at 8:30, right? for the sentencing?
Yeah, correct.
Okay. July
27.
8:30, yeah. And then just, I know Mr. Goodrich was talking to the court about it. I think that was the Mr. Black sentencing, is that?
We reset that because LP does not have anyone available to go and pick him up.
Okay. What date was that?